I see the numbers are still going, but I think we should start. Thank you again for making time for today's seminar. Some have attended all three, but today this is the seminar in a series of three. In the first seminar, we looked at recent developments through case law. We picked up two cases where environmental law was the focus and considered what those meant. And in the second seminar, we considered developments in the climate change regulation space and focused on the developments in the legal framework. And today we are dealing with extended producer responsibility, the regime behind it. And for that, we've got Claire Tucker, who heads our practice, to present on it. Putting those aside, and as I say, we appreciate you taking time to join us this afternoon. As with the previous sessions, this should be very interactive and will take questions at any time. However, because this is a webinar, you are muted, you cannot speak, but you do have an opportunity to use the chat or question and answer screen. So you could put through your questions at any time, and if it relates to what we're discussing at the point, we'll raise it immediately or hold it over till the end. Thank you and enjoy. Over to you, Claire.
Super, thanks a lot. Hi, everyone. I think it is a slightly more niche topic than some of the others that we've covered, such as recent developments. But I think it's, we thought it was sufficiently important that there may well be some people out there who are very interested in the new developments that there have been in extended producer responsibility. And so we thought it was worthwhile putting this together for those who are interested in it. Sorry, I've been having a little bit of trouble with my strange slideshow. Okay, there we go. Okay, so yeah, a slightly more niche than others, very much focused on the Waste Act. But I think that the reason why the extended producer responsibility regime and the new directions are important, because it's something that is going to impact in due course, really on all producers in whatever sector they're in. And I think that, what we see is the department trying to reach out, to listen a bit maybe to industry, and also to sort of cast, potentially a new way of dealing with waste and extended producer responsibilities in the industrial context. So this is the first time we really see extended producer responsibility regulations coming up, but they have quite an interesting genesis. Obviously, the Waste Act itself has been around for more than 11 years, and certainly the department has been talking about extended producer responsibility for a long time. You may think that we've already had extended producer responsibility programs in place, and that's because in the past we've had industry waste management plans, which have been required and have been instituted, but they're actually two slightly different concepts, and they're dealt with in a different way under the Waste Act. In the past, they used to talk about sort of voluntary and mandatory EPRs, and there's obviously a range of different sorts of policy interventions that can be used for extended producer responsibility. In the voluntary regime, there's a lot of talk about education programs. There's a lot of talk about sort of voluntary return programs and that kind of thing. But we're now starting with the December 2019 policy, which is allied to the time period when the department indicates a change of approach, to Minister Creasy starting to really try to get the department's head around what extended producer responsibility is going to mean. Just got one of these quotes from her, which was something which she said at the plastics colloquium. The circular economy requires integrating the entire production cycle from raw material extraction, product design, use, ultimately recovery, recycling, or reuse. So you can really see that thinking starting to emerge. And at the same time, in 2019, we also have the State of Waste report, which was published for comment, saying that extended producer responsibility was the preferred economic instrument to reduce waste generation. And you'll see that I start to talk quite a lot about the economic provisions under the extended producer responsibility, because obviously the financial end is where we're all interested in it, the financial end, and whether it is in fact going to amount to a new tax on producers, whether it's going to amount to a new tax on consumer goods, whether it's going to amount to a new tax on all sorts of industrial goods, is what we're all really interested in. And I think it's probably been one of the most contentious issues under the Waste Act itself. We've had a long debate about the Waste Management Bureau, about how it should be funded, about whether it will in fact impose new taxes in order to drive waste management and waste reduction. So, you know, economic instrument is always the sort of area where we really start to prick our ears up, and we'll try and explore that in a bit more detail. So like Wandi said, it is a smaller group today, as I say, a bit of a niche. So I really am very happy to have debate, comment, what people's reflections have been on the extended producer responsibility, any disagreements that people have with what I'm saying. And obviously, as I say, as soon as you start talking financial consequence, you do get quite a few different opinions. So there was this initial call up in 2017 for the paper, packaging, electrical and lighting industry. And you'll see that this is exactly aligned with the extended producer responsibility scheme call-ups that we had in June, well, the draft call-ups that we had in June this year, which we're sort of talking to in this topic. So in 2017, those specific industries had a notice under Section 28 requiring these industries to submit industry waste management plans to the minister. This is what last year was ultimately withdrawn. And we'll all know that there was an awful lot of debate when those regulations came out. A lot of the existing waste minimization, waste management agencies responded to the call up that was put out. But there was so much vagueness in the industry waste management plan regulations that were put out that it was quite difficult to respond. And also a lot of people felt it was premature for there to be a response, because a lot of the funding methodologies under those regs hadn't been properly developed. And so it was almost impossible to meaningfully respond to them. So the minister, in withdrawing them last year, said that a number of plans had been received, but none had complied with the criteria, and so none could be approved. I think a lot of this was around the fact that under the criteria, they wanted a whole load of economic responses, but given the uncertainties that there were at that time with how exactly funding was going to happen, a lot of people had responded sort of really just saying, look, this will need to be subject to further debate. So Minister Creasy then last year in December acknowledged that a new approach was required to achieve the objectives. And the new approach would be centered rather on extended producer responsibility principles rather than industry waste management plans. And, you know, it's, you know, I think that you have to be quite dedicated to the waste industry to really be able to properly discern the differences at a conceptual level between an industry waste management plan and an extended producer responsibility scheme. Both of them are really talking about responsibility resting with the entity or the industrial participant that causes waste to ultimately deal with that waste through the life cycle. But you'll see that in fact, even though the concepts for me probably are pretty similar, the way that the Waste Act deals with them is quite different. And the mechanisms under the Waste Act for dealing with them are quite different. And so what we're doing is we're moving from industrial waste management plans where people were really trying to get to grips with them into the extended producer responsibility scheme world. And as you'll see, unfortunately, in publishing the Extended Producer Responsibility Scheme regulations, they haven't really gotten us any closer to clearing up a lot of the vagueness that previously existed. So these then are the proposed regulations, which were published in terms of Section 18. There's the general regulations, and then there are the various schemes, which were published. And I think there might be one missing there. Yeah. Okay. So again, complete alignment with what there was previously in terms of the industry waste management plans in terms of sectors, but we're now using a different section in order to achieve it. So just very briefly, this is Section 18. Interestingly, it requires this consultation with the Minister of Trade and Industry. There's no indication in the draft regulations published that that consultation has happened, but that wouldn't be fatal to the publication of the draft, and presumably this is one of the consultations which the Minister will undertake, having published the draft regulations. So at an overview, this is the sort of thing that the proposed regulations cover. And I think that the next slide, okay, all right. So these regulations now are targeted at producers, and we'll spend a little bit of time looking at what that definition of producers means, because obviously that's a key consideration as to who exactly would be affected by these regulations. The EPR measures must be implemented by producers, but that can be done through an extended producer responsibility scheme. And, you know, I think that this is amongst many of the difficulties with the regulations and with what they are purporting to do, because as with all of the environmental statutes, we'll discuss at the end, there are huge criminal penalties associated with non-compliance. But the sort of notion of how you're supposed to get someone to, you know, a third party to undertake your obligations, and what happens when they don't, and, you know, how you get knowledge of the fact that they're not undertaking their obligations properly, all of that is still pretty unclear. And it's almost difficult to understand how producers could allow the scheme to operate without having a large degree of oversight over their operations, and sort of quite a bit of complexity around those institutional arrangements. So the regulations themselves set up a range of minimum requirements and criteria. I don't go into those in any detail here. They kind of relate to matters such as exactly how the scheme should undertake its extended producer responsibility, and quite a lot of quite technical detail there, which I think, again, you know, they obviously have something quite specific in mind. So on the one hand, there's a lot of detail. On the other hand, they sort of then pull back. I think on that, obviously the very important part of these regulations is that it is the scheme and the producers themselves that manage and control the scheme. And we'll discuss that that is a key move away from how the industrial waste management plans were originally conceived. So there's a lot of detail around financial arrangements for the scheme, but those are really pretty unclear. There's provision for monitoring, reporting, and evaluation, and there's provision for performance reviews. Also, registration, operational requirements, and obligations of these producer responsibility organizations, which can run a scheme. Again, they have quite specific thoughts around what that should be and the sort of institutional structure. It should be a not-for-profit company established by producers, or established by a group of producers in order to support implementation of the scheme. So the actual measures which the regs require of a producer is either to establish or to implement a scheme or to join a scheme. You remember one of the controversies around the industrial waste management plans was there seemed almost to be this notion that there was going to become a sort of default recognized scheme, which you would end up having to belong to because your scheme couldn't be approved. But if there was a scheme approved, you were going to have to join up. That kind of notion seems to have fallen away, because as I'll discuss in a moment, it's quite unclear how a scheme actually gets approved in the first place, and what the sort of what the technicalities around that is going to be. So the producer, as I say, becomes fully accountable for the performance of the scheme. Now, obviously, where you've got this NGO, as a matter of fact, running the scheme, holding you fully accountable for the performance of it is pretty difficult and pretty tricky, particularly in a context where the department is monitoring, the department is receiving reports. One would imagine there that the department would have a degree of responsibility for actually undertaking all of the monitoring that is established under the Act. They also have a responsibility to finance the scheme. So there are quite tricky arrangements around how that's supposed to happen and how budgets are supposed to be developed to fund the scheme. The producer must also develop and maintain the system to collect the fees. So, and here again, the way that the regs are drafted, they sort of interchangeably place all the same obligations on producers and on producer organizations. So as the producer, you have this responsibility, and then as the organization, you have the responsibility. There must be internal audits. There must be an independent financial auditor. Must develop and maintain a register of members and a data collection system. Sort of, it's quite specific that there must be tenders and then contracts for collection, sorting, recycling, and recovery of waste. So quite a specific provision around that. They must establish new infrastructure to promote the effective implementation of the extended producer responsibility scheme. So that's quite interesting. Sort of almost as a requirement, you can't be relying on existing infrastructure, which I suppose accords with the fact that you're supposed to be extending it. But to the extent that an existing scheme is well functioning, that does seem to be an interesting requirement. And then there also has to be a broad-based Black economic empowerment charter within the sector, which I think we don't need to dwell on for now. So just to think about some of the features of what we've seen. So as far as I can see the regulations, there isn't an approval for a plan. So this is obviously where the integrated waste management plan approach really fell apart, because they provided for a very strict regime in terms of which your scheme was only approved, and so you were only in compliance with the regs once it had been approved by the minister. There's no provision for approval. So sort of how you know that you're on the right track, and how you know that what you're doing is acceptable is a bit unclear. So obviously this is in contrast to the fact that a lot of people submitted plans which weren't approved. The one approved plan that there was, or the one approved scheme, which obviously went through various different iterations, was Redisa, which obviously ended up imploding. That was the waste tire industry waste management plan, which really all ended in tears. So although there's no provision for approval, there is something strange in the regulations where they speak about agreement. It doesn't say agreement with whom, presumably it's with the department. It doesn't say how you solicit this agreement, but it's an agreement on individual targets. So it almost seems to contemplate that there will be individual targets for schemes and that these will be agreed. So you approach the department as a scheme with your sort of individual targets, and you then get those agreed. Interestingly, the Waste Management Bureau doesn't really feature in these regulations. Now, the Waste Management Bureau is obviously something new that was inserted into the Waste Act. And it is, as a matter of fact, as I understand it, the bureau that's responsible for managing Redisa. Now the sort of newly imploded version. So section 34D and E, which deal with the functions and objects of the Waste Management Bureau, speak a number of times about that responsibility for integrated waste management plans. But those sections don't, in fact, mention extended producer responsibility schemes. So the regs don't deal with it. The Waste Management Act doesn't deal with it, but it does seem to be strange if we're almost saying that we're now going to have some sort of a parallel process within the department in which extended producer responsibility is going to be managed. There's going to be meetings and agreements on targets. There's going to be monitoring. There's going to be submission of reports and receipt of reports. But it isn't clear how and where that's going to happen within the department. A big feature of these integrated, of the EPR schemes is that they are entirely run and operated by the producer or the organization itself. So it is entirely internally funded. It budgets itself. It budgets in order to meet targets for itself. And it then operates as a self-standing entity. So there's no provision for central collection or disbursement of fees. And this was a very controversial aspect of the Integrated Waste Management Plan, where there almost seemed to be a notion that there was going to be a disbursement by the Waste Bureau of funds for these integrated, for the industry waste management plans and the organizations to function, and that there was going to be a collection of the fees by the Bureau and then dispersed downwards, which obviously, you know, people were very unhappy about and really didn't think it would work. So I think this is a real element where the department and the minister has listened to the concerns that industry had. But unfortunately, in creating this regime, they've also created some oversight of the regime, which is very unclear. There's a requirement that a producer submits a financial plan and budget, presumably to the department, but it's unclear to what end, whether that financial plan and budget is then approved or not approved, and you know when that sort of communication happens. And I think probably the most confusing institutional feature of what's being contemplated is that there is a notion that the actual fee, in other words, the amount that is going to be added onto products which are subject to the scheme, is going to be determined and fixed. But what the regulations say is that it's the producer who will determine the fee, and that will be in consultation with the Minister of Finance and the Minister of Trade and Industry and Competition. So I'm going to come back to that provision and just explore it a little bit more in a moment. So yeah, this is just the provision. The producers must determine the fee in consultation with those two ministers. The fee must be based on a differentiated rate per item category, dependent on weight, recyclability. The fee must be paid by producers and is used to fund the scheme. So effectively, on each product that you produce, there will be a fee. So say whatever, 5 cents on a plastic bottle. That then obviously as the producer, you can pass down the chain and ultimately collect from the consumer. You as the producer pay that over to the scheme, and the scheme uses the aggregation of those fees in order to fund itself. But the fee, the fee is kind of driven by the fact that the scheme determines its budget, how much money it needs in order to carry out its programs. It then sort of sets the fee based on how many items there are that will be produced overall. And so there's a kind of a chicken and an egg, what comes first, the scheme or the fee? And it also seems that the producer has an individual financial plan and budget, or the scheme has an individual financial plan and budget. So I think that, this definitely seems to create a fairly confusing regime. I mean, obviously this consultation obligation with two ministers is practically impossible for a private party to carry out. And those two ministers are not acting under any power that they have. There's no legislative power which they are exercising other than the fact that under these regs, they seem to have been given a power, as a statutory empowerment matter, it's very difficult to understand. There's no provision for involvement by the Department of Environment, the Minister of Environment, or the Waste Management Bureau, insofar as that interaction is concerned. It's not that you must also, do that in consultation with the Minister of the Environment. It's in consultation with 2 other ministers. And, I really know of no precedent for a private party having to seek that sort of concurrence for their actions. It's also unclear what the criteria are that those ministers would apply in considering it, as they don't, as I say, they don't have a specific mandate around managing waste fees, or presumably the Minister of Finance would want to make sure it isn't too much of a tax or something, but you can't impose a tax other than through a money bill, so it's just pretty confusing. Also, producers are liable to pay the EPR fee, but each producer could pay a different amount based on their individual discussions with these ministers. And so then you could have a scenario where different products have a different fee associated with them, depending on who the producer is. Obviously, everyone would want their fee to be as low as possible, because you don't want to be creating an uncompetitive disadvantage for your product in the consumer market. So yeah, I really think that those provisions require more thought. Other concerns with these financial arrangement schemes is it's just so vague. And as soon as these regulations commence, you're effectively supposed to create your scheme, and within 6 months you are required to have it all up and running and to be registered and to be running it. But as I say, there's a chicken and an egg as to working out, well, how much money are you going to have? You need to agree on individual targets with someone, then determine how much money you need, then determine how you're going to set your fee. But obviously the difficulty is that there could be multiple of these schemes operating at the same time. Producer encompasses a number of different persons, amongst others manufacturers, brand owners, and importers. So again, how are you going to make sure that you don't have duplication within the market and that it's harmonized? Obviously, one way is just to have one scheme for the whole industry. But I think, we've seen in the past that quite a lot of producers are not really all that keen on just having a single scheme. They want to be able to create some, that they may not necessarily trust the scheme, or they may fall out with them and they may want to go with another one. So you definitely are likely to end up with more than one scheme. Yeah, and I think again, a lot of this differentiation is quite difficult to understand. A lot of these consumer goods that are going to be in the market actually have multiple call-up components in them. A plastic bottle would have a bottle and a lid and a label. Each of those, is initially produced somewhere and is then put together, and it's very unclear how that value chain flow works. Also, as I say, this differentiation per item, very often you sell a collection of bottles all together, 24 of them in a box, which is paper. So there's plastic bottles inside a paper box, inside, and it's sort of aggregated. And it was very difficult from the regulations to work out how you put that aggregation together and come up with something sensible. Yeah, and then also just this weight and recyclability of each item. But again, you making up the product, you could have quite a few differences in that. So as I say, there is a provision for monitoring, reporting, evaluation, etc. And here again, there's very onerous requirements, but it's kind of unclear what happens, you know, what exactly it is that you're reporting on. There are these individual requirements or targets, which they say are going to be set. You know, obviously there'll always be reasons why you may or may not meet a particular target, especially in the early years, but you have to submit 6 monthly reports to the department on meeting the targets. There's an external report, there's a performance report, and then there's reporting to the waste information system. And there's also a 5-yearly performance report, which the department carries out. So, you know, it's, although there is a lot of freedom in the scheme, there still is quite a lot of oversight, but the nature of the oversight is pretty unclear. So, as I say, you can carry out your obligations as a producer through a producer responsibility organization, but they have quite specific thoughts about what exactly it's going to be. It must definitely be an MPO. It must have these representatives throughout the value chain, managed by a board of directors, established by producers. So they've got quite explicit requirements, and there are definitely existing producers that may need to, you know, change their existing modus operandi in order to comply. A range of responsibilities, which again are almost the same as the responsibilities on producers. So you've got this independent board of directors that is, and you know, managing the producer organization. But if you're a producer, you don't seem to, there's no basis on which you are able to sort of pass on any of your liability to that organization by belonging and paying your fees and you know, expecting them to get on with it. The producer obligations still seem to continue, notwithstanding the fact that you've sort of joined up joined up an organization. So yeah, just as I say, always a similar level of imprisonment and fine and etc. That we see in these sorts of environmental statutes. Yeah, so I mean, there's not, you know, these are obviously all just draft regulations. I think there have been a lot of comments on them. They were sort of published in the middle of COVID. They were initially published for 30 days. The 30 days was extended until the end of August. You know, I definitely think that there is some more thinking that needs to be done. The extent to which the department is responding to that, I don't have particular insight at the moment into. So I think that the flexibility to develop your own scheme is definitely preferable, and it's something that industry has kind of been campaigning for. But it does sit, you know, it's sort of one thing to say you can do your own thing, but then, you know, there's very vague, ambiguous requirements, but then at the same time, extremely rigid requirements. You know, you must have a fee, it must be approved by someone, and, you know, there's all sorts of ministers involved, but it's unclear what will get that a tick. And then in a context where, you know, there are these extremely significant penalties associated with non-compliance, and also no transitional period at the moment, you know, sort of 1 or 2 years to allow people the time and space to establish themselves, to get the approvals that they need, etc. And I think, you know, you definitely need that sort of transitional period in order to comply. Yeah, and then I do think that there are aspects that are very vague. You know, it could be that an existing producer responsibility organization, you know, would be able to do all of this in 6 months. But I think even for them, you know, there would be a reconfiguration, there's approvals, there's consultations that would be needed. So yeah, I definitely hope that the department is going to be responsive to the fact that this is sort of going to cause a significant, not disruption, but change. I think we've all known that this is coming for a long time. And it is just a case of trying to work out a sensible way to comply. But I do think that, you know, there is going to be more time that's needed in doing that. So yeah, I think that that's probably my bag.
Thank you, Claire. I think that was quite interesting. And as you've just indicated towards the end, this is the developing regime and part of draft regulations. Although developing regime, it has features we have seen before, always coming with good intentions. But as you look into it, you do find some difficult concepts that you just have to engage with them as you go along. The transitional provisions, ensuring that the relevant authorities have requisite powers and authorities to implement, allowing people sensible time not to overpunish. I think what one of the people in the audience, Trish, as she was leaving, she recognized the importance of this topic, and because it is evolving, she is suggesting that we should have another one once the final regime is in place and know for sure what are the implications. And with that, I agree, which also sort of takes me to extend this sort of invite to everyone in the audience that we do welcome these kind of suggestions. If there are topical points you'd like us to cover next time, we would appreciate covering them. And then the other question that came through, which I think as it came through, you answered it when I was about to put it to you. It was to come in, what are the consequences of not applying with these obligations? And as you've shown, it's criminal imprisonment, fines in circumstances where obligations aren't entirely clear and not been given sufficient time to put your house into order.
Yeah, I think there's definitely going to be a need, as you say, Wandi, to keep engaging on the topic. I don't think anyone in a sort of industrial economy these days doesn't expect there to be extended producer responsibility. But, you know, we do need a regime that's clear and that can be fairly applied. I think that otherwise the next seminar may be on how we can launch a class action to get the irregular regulation set aside. I hope it doesn't come to that, but I certainly think that there's potential for that in their present formulation.
Yes, thank you. Besides those two comments, I don't see any. Hopeful to have a hybrid one next time, because with the hybrid, I was going to hand over mic to anyone closest to me to say, can they give their reflections? Thank you very much, Claire, and thank you everyone for attending. And as a parting shot from my side, we already open to suggestion what people would like to talk to. And even as Claire was saying, some of these areas are quite niche areas. Should there be a need for a focused discussion, either with a group of clients or group of association, would more than come to have those engagements and work out what needs to be done. Thank you for your time. Thanks.
Thank you.